Chapter 7 of Tractate Shevuos covers the laws of biblical and rabbinic oaths. The first Mishnah says, somebody who takes a biblical oath in court does so and thereby exempts himself from any payment. Then there's a rabbinic oath, which is taken to collect payment. This is done by a hired worker, a victim of theft, a victim of assault, if the opposing litigant is suspect of taking false oaths, and a storekeeper for what's written in his ledger. A hired worker would take an oath to collect payment if his employer falsely claimed he was already paid. Rabbi Yehuda says it only applies if the employer admits to paying part of the wage. A victim of theft swears an oath, for instance, if somebody breaks into a man's house to steal something as collateral for his debt and then claims he took nothing, the other man can take an oath to reclaim it. Again, Rabbi Yehuda says this only applies if the man partially admitted to theft. A victim of assault would swear an oath if somebody entered a man's property whole and left injured, and the other man claims he didn't injure him, he can take an oath to be compensated. Again, Rabbi Yehuda says this only admits if the man partially admitted to theft. Somebody suspect of making false oaths, whether because in the past he had taken a false oath, or he's just a dishonest person, somebody who gambles, lends on interest, or otherwise, the other man instead takes a rabbinic oath. If both parties are suspect of dishonesty by oaths, some say the oath returns to its place, which will be defined soon. Others say they just divide the contested amount. Regarding a storekeeper swearing by his ledger, it would be that somebody requests of a storekeeper to give his children or workers some food or change, and the storekeeper later claims he did this based on his ledger, but the children or workers say they never received the food or money. So the storekeepers and workers all take oaths for this and collect money from the employer. Others say these are vain oaths, so they just collect the funds without them. Related, if somebody told the storekeeper to give him a dinner's worth of produce, which the storekeeper gives, and then requested his dinner, so the man said that I already put it in your money purse, he must then take an oath that he had done so. If the man requested this produce, and the storekeeper said he already gave it, and you'd taken it home, he must take an oath that he had done so. It's said that whoever has the produce in their possession has the upper hand here. Similarly, if somebody told a money changer to give him change for a dinner, which the money changer gives, and then requests his dinner, so the man said, I already put it in your money purse, he must then take an oath that he had done so. If the man requested his change, and the storekeeper said he had already given it, and you'd put it in your purse, he must take an oath that he had done so. It's said that a money changer typically won't give a single coin in change until he receives the dinner. As was discussed back in Tractate, Shevous, if a woman admits to collecting part of her marriage contract, she can only collect the remainder with an oath that it was not paid in full. This would also apply if a single witness says the marriage contract was paid. Also, a woman would require an oath to collect her marriage contract from encumbered properties or from orphans' properties. She would also need an oath to collect her marriage contract outside of her husband's presence. Similarly, orphans can collect debts owed to their father with an oath, which it describes. This would apply even if the son was born after the father's death. Some say if people witnessed the father saying the particular document was unpaid, the sons don't need an oath to collect it after the father's passing. The following must all take oaths even without a definite claim against them: partners, sharecroppers, administrators, a woman who keeps a store for her husband, and a member of a household. By any of these, one party can request of the other to swear they've taken none of their property, and the other must then take an oath. This cannot be requested at a later period, but if later on an oath becomes necessary, they can also request oaths for prior incidents. The sabbatical year cancels liabilities to take an oath. The Gemara begins going through scriptural sources for these principles. The reason why rabbinic oaths were instituted for hired workers was because it's a major law, which is described further, although some say it as its lasting enactment. Some say it's just as employers have many workers, so could easily make mistakes, so this was instituted to reduce issues. There are further points on this. It said, by oaths between an employer and employee, this only applies if the employee was hired before witnesses, as if he wasn't, the employer technically had the option to just deny ever hiring this individual. It further discusses this, along with some related points. There are additional particularities brought in these points. It's established that some hold the oath is administered to the worker, even if the wage amount is disputed. There are further points on this. The case of theft, we said, was somebody stealing collateral. The claim has legitimacy, as it's where he saw the thief leaving with something smuggled under his clothing. Related, it's established if somebody leaves somebody's house after hiding utensils under his clothes and then claims he purchased those, he's just not believed. This applies if the original owner does not typically sell his utensils and with items that aren't typically hidden, and if the thief isn't typically a secretive person, and only if the original owner claims that they were borrowed as opposed to stolen, as that would require more definitive proof, and only regarding items that are typically borrowed or rented. And there are supports and some unresolved questions on this. If somebody claimed the thief stole his silver goblet obligate. If the victim is wealthy or trustworthy or somebody who people deposit expensive items with, he can take an oath, otherwise not. Regarding the case of somebody's injury, where he entered a house and left with a wound and took an oath that somebody hurt him, this applies specifically to an injury that could not be self-inflicted, such as a bite mark on his back or his torso, and there was no one else there besides for the alleged attacker. It clarifies the points on vain oaths. We mentioned a gambler and otherwise cannot take oaths, establishing those prohibited by rabbinic disqualification. If both litigants were suspect of taking false oaths, it was a debate, and some say we just don't know what the law there is, others say it's just divided. One of the opinions was that the oath returns to its place, which is explained to mean that the status quo is just maintained, as they have oaths from Mount Sinai anyways to not steal. It additionally discusses sources for this. It also explains the remaining points from the Mishnah, along with some related points on witness testimony. It explains the points between lost collateral. It says it brought cases of both produce and money changers, as produce spoils, so people don't postpone transfer typically, and as mentioned by a money changer, they don't typically give money without first receiving recompense, so both cases are listed. It also clarifies the remaining cases by marriage contracts and orphans. Some held that a lender's orphan can only collect from a borrower's orphan if the lender died during the borrower's lifetime, as otherwise a person cannot give over a debt to their children. Others dispute this, and it's discussed further. There are further points on this, along with several related incidents that are listed. It's a rule that doing like either opinion is allowed. However, generally a document that belongs to a lender's orphan who died after the borrower, we just do nothing with it in such a case, as we're unsure who we rule like. The remaining steps from the Mishnah are qualified setting sources, and it also proves that by partners or sharecroppers, we can require an oath from a rabbinic oath, as they're allowed to require oaths from earlier incidents to be taken based on a later oath. Some clarify this specifically does not apply by oaths of hired workers, where we're more lenient. Lastly, it said that the sabbatical year cancels liability for oaths, which is sources from a verse. And that's the end of chapter 7. Chapter 8, the final chapter of Tractate Shevuos, covers some final laws of oaths of deposit. The first Mishnah says there are 4 types of guardians, say for animals: an unpaid guardian, a borrower, a paid guardian, and a renter. An unpaid guardian takes oaths by everything to avoid liability. A borrower would need to pay for any damage to the item, and a paid guardian or renter swear oaths by an animal that was damaged that they're not at fault, and if the animal was captured or died naturally, they would pay for loss and theft. If an unpaid guardian takes a false oath that an animal under his watch died naturally when it had actually been captured or otherwise, or he said it was captured when it actually died or otherwise, or he said it was lost when it actually died or otherwise, there's exemption from bringing an offering for this false oath. If the unpaid guardian denied ever having been made responsible for the animal and took an oath, he'd also be exempt. If the unpaid guardian claimed the animal was lost and took an oath, and then witnesses testify the guardian had eaten the animal, the guardian must repay the value of the animal. If the guardian had admitted himself that he had eaten the animal, he needs to pay a 5th charge and bring an asham offering for the false oath. If the guardian said the animal was stolen and took an oath, and then witnesses testify he had stolen it for himself, he must repay double. If the guardian admitted to his theft by himself, he pays a 5th and brings an asham offering. If somebody accused another man of stealing his ox, and the man denies this, and then witnesses testify he had stolen it, he repays double. If witnesses testify he has slaughtered or sold it, the thief pays 4 or 5 times payments, depending on the animal. If a thief sees witnesses coming and then quickly admits to stealing the ox only, he pays the principal value of the ox. If somebody demanded his ox that he had lent to somebody and the man said it died naturally when it was actually stolen or otherwise, or he said it was broken when it had died naturally or other similar cases, and takes an oath for this, he would be exempt for the false oath. If a lender demanded his ox and the man denied ever having borrowed the ox and took a false oath, he would be liable for the false oath. If somebody requested their ox from a paid guardian or renter and they said it died when it had actually been captured or otherwise, and they take an oath, there's no liability for it being false. If they say the animal died or was captured or otherwise when it was actually lost or stolen, they would be liable for a false oath. If the paid guardian or renters say it was lost or stolen when it had actually died or was captured and they take a false oath, they're exempt. The general rule is anybody who admits to liability but of a different type, or exemption but of a different type, is exempt for a false oath. If they change from liability to exemption, they're liable. Generally, if somebody takes a false oath to make things more lenient for himself, he's liable. And if it makes things more stringent for himself, he's exempt. The Gemara mentions the sages who source these points on the 4 different types of guardians, although it mentions there are technically only 3 laws between them, as mentioned. It's a debate by all these cases if there's not liability for false oaths of a guardian, although it's a debate if there's liability for false oaths of utterances. It discusses this and it brings sources for the former opinion that there is actually liability for false oaths of utterance. Although it said this would specifically not apply by the false oath of a borrower who says he has no knowledge of ever borrowing the animals, and the case of the paid guardian or renter where the animal was lost or stolen and they swear falsely that something unavoidable occurred to it, as in those cases there's liability for a false oath of deposit as he denied owing money. And that's the end of chapter 8 and the entire Tractate Shevuos.